Thank you to everybody for joining us for today's webinar on the topic of trade remedies, which may of course be a new area for some. And even if not, it's still safe to say that it's an area set to appear far more on UK lawyers' radars over the next few years than has perhaps been the case up to now. From now on, issues and decisions about trade remedies will be UK-centred as opposed to being geared to the needs of the EU as a whole. We very much hope that this is going to be the first in a series of webinars on the subject of the UK's trade remedies. Items that we plan to cover in future include, amongst other things, what actually happens in trade defence investigations, which investigations are currently being carried out and the issues they raise, and also potential judicial review questions relating to decisions by the new Trade Remedies Authority or the Secretary of State for International Trade. So trade remedies law is an important and developing area for the UK as we start imposing our own trade defence remedies in the place of the European Commission. The UK has adopted specific legislation enabling it to take over the Commission's function in the shape of the Taxation Cross-Border Trade Act of 2018, particularly Schedules 4 and 5, together with 3 2019 statutory instruments, 2 of those on issues of substance and a third on the processes and tests for reconsiderations and appeals. And we've attached links to the key legislation in the PowerPoint slides for this webinar, and you'll be able to click on them and hopefully get the links in due course. The fact that the UK is a member of the World Trade Organization means that because of its WTO agreements, it is only able to operate a trade defence instrument system within the confines of WTO stipulations. These govern when remedies may be imposed. Essentially, measures can be applied in derogation from the international rules on bound tariffs levied on goods following GATT negotiations and the most favoured nation principle if the trade practices being looked at can be shown to have caused material injury to a domestic industry. And that's set out in, for example, Article 5 of the WTO Anti-Dumping Agreement, Article 11 of the Agreement on Subsidies and Countervailing Measures, and Article 2 of the Agreement on Safeguards. The tightrope that's walked with trade defence measures is between, on the one hand, preventing injury to affected industries as a result of what are deemed unfair trade practices, and on the other, introducing remedies that are themselves seen as protectionist and unfair, or that may not be in the economic interests of a UK industry group as a whole. The Commission has, we note, frequently found itself as a defendant in either the EU or WTO courts as a result of measures it has adopted, and one can therefore expect the area to generate some litigation in the UK in future too. The UK legislation sets up a brand new non-departmental public body, the Trade Remedies Authority, or TRA. The TRA is staffed with lawyers, economists, and other investigators. And as Fergus will explain, the same organisation is currently operating until 31st of December of this year as the Trade Remedies Investigations Directorate, a part of the Department for International Trade. It is engaged in conducting reviews in order to transition EU remedies, where appropriate, over to the UK system. Once the transition period for leaving the EU ends on 31st December, the TRA will assume full competence for UK trade remedies. At the moment, it has a chair designate and an interim chief executive who have been selected and are awaiting formal confirmation in post following parliamentary committee hearings. In fact, a session with the House of Commons International Trade Committee took place earlier this week, I think on the 25th of November, to inquire into whether the TRA will be ready to fulfil its role by the end of the year, and the session could be watched online. Everything is therefore about to get going, and we've identified, and perhaps if we can go to the next slide, 7 different points to look at in outline today, which you should be able to see on the screen now. The schema that we've adopted is to go back and forth between Fergus and myself, making some observations on each of them, and then to allow a little time for some questions at the end. Overall, we hope that what we say is a helpful introduction to the topic. So over to Fergus.
Thank you very much indeed, Sarah. Little did I think some 35 years ago when I started my career, first legal service in the Commission and then in private practice when I was doing a lot of trade work, that I'd be talking to you today on trade issues. Very similar, but also importantly different. And that's where people may get tripped up, and we're going to try and shine a little light on the position as it is at the moment. Slightly complex, given the fact that we still have negotiations ongoing, but one thing won't change in those negotiations, and that is the end of the transition period. That ends, as you probably all know, at 11 p.m. English time on the 31st of December. That's exactly 5 weeks today. And we'll no longer be governed, I say we, the UK, will no longer be governed by the EU's trade policy, which to date has been the case. Now, without its own trade policy, the UK would have no ability to take measures to protect UK industry from unlawful practices from abroad, and hence the need for new domestic measures. Now, as Sarah said, since January of this year, so 2020, the Trade Remedies Investigations Directorate, TRADE, which is the predecessor organisation to the Trade Remedies Authority, which will take over at the end of the transition period, has had the power to act on behalf of the UK Secretary of State in cases where the EU has trade remedies in place, and in particular to assess whether they should be replicated going forward or allowed to lapse following an assessment of, amongst other things, the UK's new economic interest test, i.e. is it in the economic interest of the UK to continue with the existing measures or not. Now, one issue has already broken the surface, and that's in relation to Chinese bicycles. Now, Chinese bicycles at present are impacted by a nearly 50% tariff anti-dumping duty when they come in to the EU, which for this purpose includes the UK. Now, the UK has decided in the summer, late summer, that actually those duties should be allowed to lapse, and that therefore Chinese bicycles should be allowed into the UK tariff-free, or at least dumping duty free. Now, that has caused a little bit of a furore. It's been in the public domain, it's been reported in places such as Bloomberg, that Brompton Bicycles and Frog, I wasn't aware of Frog, but anyway, Frog is apparently a domestic bicycle manufacturer, they are upset. And apparently the matter is now being reconsidered. One of the issues was that it was not thought that those parties that had complained formed a substantial enough part of the UK industry. And as one understands it from the press reports, that is going to be one of the major areas for determination or redetermination. So that is the present jurisdiction. In fact, that jurisdiction of review, effectively, of looking at existing trade measures taken by the Commission, has been extended. It was extended in August of this year to open investigations into the possibility of imposing trade remedies in respect of imports into the UK in cases where the EU has already started an investigation but not actually come to a decision. As I said, as at 11 p.m. On the 31st of December, so in 5 weeks' time, the TRID's jurisdiction will pass to the TRA, the Trade Remedies Authority, which is a body set up under statute. And I say under statute, in fact, it's contained in the trade bill. Now, the trade bill is presently in Parliament. It is due to have its report stage in the House of Lords on the 7th of December. So things are being cut pretty fine. And one thing one can see from the trade bill is the interplay between the Secretary of State and the TRA in terms of guidance, and this can be found for your notes, if you're taking notes, at paragraph 34 of Schedule 4 to the Trade Bill, and it says, in performing its functions, the TRA must have regard to guidance published by the Secretary of State. Before publishing the guidance, the Secretary of State must consult the TRA and have regard to the expertise of the TRA and the need to protect its operational independence, rather important. Then it says, in particular, the Secretary of State may not publish guidance in relation to a specific trade remedies investigation. And also the obligation on the TRA to have regard to guidance doesn't apply to ongoing trade remedies investigation if that guidance is published during the course of the investigation. So that I would suggest will be an interesting area for exploration by lawyers in particular cases. The areas in which, and I'm just finishing this section, the areas in which decisions by the TRA can be taken fall into three categories: well-known, anti-dumping, anti-subsidy, and safeguarding. Anti-dumping remedies, as you all probably know, address imported goods being sold in the UK at prices which are below their normal value in the country from which they are exported. So you're comparing normal value with export price. Countervailing remedies address imported goods which are being subsidized by foreign governments. And safeguard remedies protect domestic industries against an unforeseen surge in imports. And finally, on this section, it's worthwhile remembering that it's not only an issue where, for example, an investigation is started by a disconcerted domestic industry participant who's being impacted by the products, or the dumped products or the subsidized products. It can relate also to measures that have been sanctioned by the WTO, and for that, the cross-reference is Regulations 10 and 20 of the Trade Remedies Amendment Regulations 2020/99. Interestingly enough, the UK have, according to Reuters, confirmed that they will be imposing tariffs pursuant to the recent WTO findings against the US in relation to Boeing, arising out of the aircraft subsidies that Boeing received from the US government. So that will be very interesting, and huge amounts of legal debate about actually whether the UK is entitled to do that. So watch this space. Sarah, over to you for what remedies can affected parties get.
Okay, so going on to what remedies affected parties can get, the answer obviously depends on the type of unfair trade practice that's had an impact on the relevant party. In the case of anti-dumping measures, the principal type of remedy is the imposition of additional duties when the goods reach the UK border. In the case of anti-subsidy measures, the usual remedy is pretty much the same. It's known as a countervailing measure, but again, it means the imposition of additional duties on imports. Concentrating for a moment on duties, the UK has purposefully adopted something known as the lesser duty rule, which means that the TRA and the Secretary of State will ensure that the level of duty won't exceed the lower of two amounts. These are, on the one hand, the dumping margin, or the amount of the subsidy, as the case may be, and on the other, the amount of the margin of the injury caused to producers. Duties can be calculated in various different ways, and the TRA has said that it will look at each case on an individual basis and decide on an appropriate remedy. The maximum length of the measures that can be applied for dumping or subsidies is up to 5 years, but the length will obviously depend on the time estimated as actually being necessary to remedy the injury in each case. Undertakings or agreements can be given in place of a measure, and these can take the form of an agreement to revise the price upwards, or in the case of a foreign government, an actual agreement to cease paying a subsidy to its producers in relation to the goods. In relation to safeguarding measures, the most appropriate final remedy is likely to be a form of temporary restriction on the import of certain goods into the UK. It will be applied to all imports of the products, regardless of where they've come from, which is an important distinction from anti-dumping and anti-subsidization. There are only limited exceptions to this. For example, where there are goods from developing countries or where there are free trade agreements with the UK already in existence. The length of a safeguards measure is limited to a maximum of 4 years in the first instance, but it can be reviewed and extended up to a maximum of 8 years. And there will be, in the safeguarding measure, the amount imposed, there will either be an amount imposed on the goods, an additional duty, or alternatively a tariff rate quota, which means that goods up to the quantity specified will be subject to a lower duty, and once that's been exceeded, a higher import duty is attached to the goods. It's worth bearing in mind that safeguarding remedies are going to be relevant in situations where there's been a very sudden and, from the UK side, hugely distorting influx of foreign goods into the domestic market. Affected parties will probably want to ask the TRA to apply a provisional remedy involving an increase in the tariff on the goods. This will be appropriate in cases where a delay in imposing a remedy until an investigation is concluded and a definitive remedy has been decided on would most likely cause damage which would be difficult to repair. So the UK has decided that a provisional safeguards measure will not exceed 200 days, during which time the TRA will carry out its investigation. I should say provisional safeguard measures in the form of duties have been fairly common to date in EU safeguard proceedings. It's possible in the case of all remedies to ask for provisional measures whilst the investigation takes place. If the TRA decides to make a recommendation to the Secretary of State for a provisional measure, it will issue its provisional determination. The maximum length of provisional measures depends on what the remedy relates to. It's up to 6 months for anti-dumping, but it can be extended to a total of 9 months and up to 4 months for countervailing measures. The importer may, instead of paying the duty immediately, be asked to provide a guarantee in respect of the payment that it would be required to make if the measures are made final in due course. And lastly, an interesting point on remedies. The European Commission has this summer taken its first decision to impose a countervailing measure in relation to a transnational subsidy, and it's also issued a white paper on the subject of transnational subsidies. These subsidies occur when a state provides a financial subsidy to a recipient in another country and limited to a particular industry or company or group, for example, a manufacturer abroad whose goods then cause a similar problem in terms of subsidized goods. The decision from the Commission was dated the 12th of June of this year, and it took action against exports from Egypt that have been subsidized by China. The Commission relied on the basic anti-subsidy regulation. And I think it's going to be interesting to see whether, if the UK is asked to do something similar, it would follow suit, and whether the legislation that's currently in place would permit such a step to be taken. Fergus.
Great. Thanks, Sarah. I'm going to do a very short section now, which is nice for me, but less nice for Sarah, on the parties. Who are the parties concerned? This is particularly relevant to all of you who are listening, who are likely to be involved in trade disputes. Obviously, you've got the exporters, you've got the importers. They will often have the same or similar arguments. You've got the domestic producers, and strictly speaking, I probably should have started there, because investigations will start normally with them complaining. So domestic producers and domestic producers organizations and associations, and other interested parties, which could include the government of the exporting country, except in relation to safeguarding procedures, trade associations of overseas producers, exporters and importers of the goods subject to review, and trade associations of domestic producers. If, and this is an if, I'm not saying it's a big if, but it's an if investigations take place along similar lines to the way in which they did and do in the EU with the Commission, there's a great deal of lawyering up very quickly. Once there's even a sniff of an investigation, associations get involved, interested parties with their lawyers making submissions. I don't know whether that's going to be the case here, but there are fairly short time frames for particular parts of the investigation. and particularly in relation to reconsideration of a decision. And as I said, the Chinese bicycle decision has been reconsidered. That's very short time frames, and you really need to be on top of not only the law, but also your client's the data. And the data is a real killer in a lot of these cases because it's just huge. And it will be, and also there are issues of confidentiality and various other things. So it's a relatively complex procedure in terms of making sure it works well for the client, and therefore one needs to be on top of everything well in advance. And that would be one free suggestion from us. Don't wait until you get a knock on the door from the TRA. You need to be well aware of the position before that. And the same thing for, obviously, for the domestic industry, to ensure that the TRA keeps going in the way that you would like it to, just as a complainant in competition cases is concerned. So that was my short passage. Over back to you, Sarah, for how can the various parties present evidence to the decision makers.
Right. So the TRID and subsequently the TRA operate an online applications process through something called the Trade Remedies service. They have an online form for applications which would have to be filled out with enough evidence to show that there's been dumping or subsidization causing material injury in the case of the first two types of remedy, or that there's been a sudden influx of imported goods of a particular type which has caused or is causing serious injury to UK producers. The application would have to include data on market share, which would require industry analysis, and any other information which may be needed to support an application. For example, in the case of safeguards, a plan by the UK producers to show how they intend to adjust to the new influx of goods once any temporary safeguard measure has expired. Others who have contacted the TRA and asked to be treated as interested parties or contributors to the investigation will also be able to provide information via questionnaires which the TRA intends to send to them, and to send any information that they wish of an accounting or commercial nature. The TRA has said in its guidance and on its website that it will, or the TRID's website for the time being, that it will consider all information it receives in this way as long as it's objective and it can be verified. One key thing is the importance of registering interest before the end of the period set by the TRA in relation to each investigation. Otherwise, an entity might find itself excluded on the basis that to include them later might significantly impede the course of the investigation. And the TRA will also refuse to issue further questionnaires once it's issued its statement of intended final determination. So the process is very much one where the TRA will decide what supplementary information it requires, and it will ask for it. But at the same time, those who've actually registered their interest will be able to supply extra information where they think it's needed. And one thing is clear, it's going to be very important for participants to be proactive throughout the whole process. In terms of visits, the TRA can conduct authorization visits to UK producers' premises to verify information supplied to it, or else to find out information which is relevant to its investigations. The 2019 regulations on dumping and subsidies, regulations 58 and 60, provide for the TRA to make verification visits and facilitation visits. And the TRID's website also refers to industry visits. Participation in the process is voluntary, but it's important to note that consequences may follow from non-participation when the decision comes to be made. There are also provisions in the regulations allowing the TRA to carry out visits to premises abroad, provided certain conditions are met. These include that the consent of the person to be visited has been obtained, and also that the foreign government has been notified of the proposed visit and doesn't object. Similarly, the 2019 regulations on safeguards include rules in respect of authentication visits. That's regulation 27 of the relevant regulations. The TRA can also conduct hearings at any time during the investigation. These can occur either at the request of an interested party or because the TRA itself decides to hold a hearing. Oral statements that are made during hearing will not be considered unless they're also committed to in writing and can be made available to other interested parties and contributors. It seems to us that the presence of legal advisors when such visits, meetings, or hearings take place is likely to be critical to ensure that clients' rights are fully protected. So in summary, the process is one where applicants and others who've registered are able to submit a wide range of materials in the form of factual and expert reports, relevant data, and so on. The TRA can choose to disregard confidential information if a non-confidential summary or statement of reasons has not been supplied to it. The TRA may also, and you can see that this may give rise to disputes as to the way that this is carried out and the correctness of ultimate conclusions, may also fill in gaps in information provided to it by obtaining evidence from other sources, whether it be from ONS, HMRC data, or industry studies and official statistics. It therefore seems an extremely good idea for parties to submit as much data as they can from the outset and to anticipate and to have regard to contradictory data at a very early stage in order to ensure that gaps are kept to a minimum and that they have as much influence over the process as possible. Evidence, including that on the economic interest test, should all be submitted during the same investigatory stage of the process. There's no two-step consideration of the economic interest test as there is, for example, before the Commission in relation to the public interest test. So what happens then? The TRA goes on to issue a statement of essential facts in a dumping or a subsidy case, and this summarises all of the facts considered and identifies those that have been relied on as well as the information that's been rejected. And in the case of a safeguard investigation, there's a similar document, but it's called a Statement of Intended Final Determination. These statements are put up online on the Trade Remedies Service website, and comments can be made by those who've supplied information during the process. It appears to be intended that parties are allowed a full opportunity to comment on the information included and on any calculations made by the TRA before the final determination is made. Finally, it's also worth noting that further information may be submitted in relation to an application for the TRA to carry out a reconsideration of its final determination. Again, similar points apply. That is, the information can be requested by the TRA, or it seems it can be supplied by the party, although the TRA may decide that it will exclude information submitted outside the relevant time limit that it set, or which doesn't conform to the request that it has made. And again, in this process, reconsideration process, it can draw information from secondary sources using its own initiative. And now I think Fergus is going to address the question of evidence required to acquire or block a remedy. And Fergus, you're muted now.
Brilliant. Thank you very much, because otherwise that would have been a bit of a waste of time. In order, I think one needs to split this into two halves, looking at how to start an investigation. The following criteria have to be met. Either it's started by the Secretary of State, and that's going to be out of most of our hands, or the application needs to be made by or on behalf of a UK industry producing goods similar, not the same, but similar to the imports they want investigated. That's one. Second criterion, the UK industry must have sufficient market share. I'll come back to that. 3, the application needs to be supported by the UK industry. Producer support for the application must be greater than producer opposition, and in any event represent at least 25% of the UK production, of all UK production of those goods. And 4th, the application must contain as much of the information required in the relevant regulation as is reasonably available. We've heard from Sarah about what happens if you don't get your information in on time. The information in question for each individual application will have to include details of prices, products, and costs. And according to the guidance on the government gov.uk website, that data, so prices, products and costs, will normally have to span a relatively lengthy period of time, say 5 years. And that's why I said earlier, this enormous production of data is going to be a real issue and something that we all have to bear in mind. Going back to market share, you'll recall I mentioned that as the first criterion. For dumping and subsidy investigations, the market share requirement is met if the UK industry's market share is at least 1% of the overall market share for the light goods in the UK. And as I said earlier, that is up for grabs as an issue in the Chinese bicycle case. Or there could be a higher market share that's considered appropriate given the goods in question in their particular market. So that's for dumping and subsidy. For safeguards, same market share requirements must be met for goods which are either like the imports in question, like goods, or are directly competitive. So that will require a degree of expertise and may require expert evidence, depending on the particular products in question, because the last thing you want is to fall at one of these initial hurdles when you've put a lot of effort in and you haven't shown to the TRA's satisfaction that you are, for example, you have met the relevant market share requirements because you haven't produced sufficient evidence. In terms of standing, relatively straightforward. For dumping and subsidy investigations, the standing requirement is met when an application is supported by the UK producers whose collective output makes up at least 25%. We've seen that, and is not opposed by UK producers whose collective output is greater or equal to that percentage. And in safeguard proceedings, so surge cases, the same standing requirement must be met, but again, for goods which are like or directly competitive to the goods being investigated. So that's standing and initial criteria. In order, obviously, to get that which you want or seek, i.e. the imposition of some form of duty, you will need to show that the injury that injury has been suffered to you, and that injury has been caused by the alleged unlawful conduct in question. Now, if all of those criteria are met, the investigation will be opened, and all the parties concerned, as we've heard, will have the opportunity to make their views known in writing and orally. A final decision as to whether to grant the remedy or not will be taken, obviously, after weighing the evidence. And again, that's going to be an issue. Has the authority weighed the evidence before it in the appropriate fashion? And as we've also discussed, and as is being played out on Chinese bicycles at the moment, as I understand it, one can ask for a reconsideration. There is an SI all about the reconsideration procedure. And if that's unsuccessful, an appeal can be brought in the Tax and Chancery Chamber of the upper tribunal, from which there will obviously be an appeal with permission to the Court of Appeal and so on. I think Sarah will be dealing with the issue of the standard of review in the upper tribunal. So over to you, Sarah, for routes for challenging a decision.
Thank you. I'm going to start, in fact, with the issue of reconsideration, because interestingly, the legislation provides for the possibility of a request to the TRA to reconsider its decision. This is set out in the relevant paragraphs of Schedules 4 and 5 of the Act, and there's also a specific set of rules in a 29 statutory instrument, again the details are further down on our slides, to do with reconsideration and appeals. In particular, it's regulations 10 to 15 of the reconsideration and appeals regulations. So the outcome of a reconsideration will be either to uphold or to vary the original decision. Who can apply for a reconsideration will depend on the type of decision that's been made. And it needs to be borne in mind, too, that only certain types of determinations can be reconsidered. For example, if the TRA has decided to reject an application, only the applicant themselves can apply for the decision to be reconsidered. In other permitted reconsideration cases, any interested party can apply. The application for reconsideration can only be made once the investigation is complete, so you can't keep interrupting the process of the investigation and ask for a reconsideration. Only a final determination can, in fact, be reconsidered. And again, there's a short time limit for applications to be made, and they're to be done again via the online service. So it's very much a sort of process of funneling everything into the TRA via the website. It's possible that the TRA would consider a request for reconsideration made out of time, but a good reason for asking them to do so would normally be needed. Provided the decision is listed in the regulations as one which is open to reconsideration, the application can, it seems, be made on almost any grounds. And it's important to note that it is conducted by an entirely different team from the one who originally made the decision. So if the application is rejected, the party making the request will be told and advised of their right to appeal to the upper tribunal. And if a further point is that if the reconsideration involves a particular point of law, the TRA can itself request that the upper tribunal considers the point and then brings the answer back to the TRA. It seems to us that the use of this reconsideration mechanism is interesting. It's no doubt there in order to ensure that determinations made are checked and are sound and that the quality of the overall decision making is good. It will be very interesting to see when appeals begin to be brought, firstly, whether the reconsideration process actually leads to alterations or even dampens down enthusiasm for bringing appeals. And secondly, the effect that any reconsideration that's taken place will have on the upper tribunal when it comes to consider the ultimate determination made on a judicial review standard. Thus, if two teams have reached the same decision, does it become slightly harder to succeed on an appeal before the tribunal? Also of note is the ability, as I mentioned, of the TRA to make its own decision, to refer a point of law at the reconsideration stage. Again, presumably this is a step designed to help ensure, particularly during the early years, that decisions are correctly made and that they won't be subsequently subject to attack from interested parties. So if some or all of these processes are utilised, there may be interesting questions. For example, if the Secretary of State then chooses for his own reasons to depart from the course decided upon in the TRA's final recommendation, one wonders how easy it will be for them either to decline or to grant a remedy, for example. As with the EU Commission findings, there is, of course, also the opportunity for judicial challenge of UK decisions, where a request for reconsideration is unsuccessful, and also where the decision is a decision of the Secretary of State. An appeal lies to the Tax and Chancery Chamber of the UK's upper tribunal, see Regulation 16 of the Reconsideration and Appeals Regulations. And there is, in fact, a specific form for use in relation to trade remedies appeals in the upper tribunal, which is on the government's website. It's Form FTC5. The upper tribunal will apply a judicial review standard rather than on the merits test, which was certainly something that had been discussed at the time the draft legislation was consulted on, and the tests are set out, regulations 16 to 18, again, of the appeals regs. This is a similar approach, the judicial review standard, to that seen in past years, for instance, in the changes in telecoms appeals through the changes to the Communications Act. Broadly, industry participants, and in this case applicants for remedies, usually tend to favour more extensive scope for appeals from regulatory decisions. But the drawbacks, of course, can be the length and detail involved in hearing these appeals. The upside, on the other hand, is the chance to reach a decision after a rigorous judicial process. I think it will be very interesting to see whether a judicial review test will prove an adequate form of scrutiny in relation to trade remedies measures, especially perhaps in cases where the information available to the TRA may have been incomplete through no fault of the TRA's, and it's had to fill gaps through its own researches in relation to public statistics and so forth. I think time will tell. The upper tribunal is likely to sit in a panel with some specialist members, and I think also to be more inclined than the administrative court to hear oral evidence. As the courts have stated repeatedly in many cases in recent years, judicial review is a broad process that can encompass many types of evidential questions and many formats, and it can adapt the nature of its hearings according to the issues before it. It may be, for example, that the panel is able to sit with an economist and probe in particular questions on causation and injury calculations, as well as to the level of duty imposed. The case law of the Court of Justice shows the difficulties of mounting successful challenges, at least in EU law, to decisions of the EU Commission on matters such as calculation, which are complex economic matters, the public interest test, which is akin to the UK's economic interest test. The CJEU certainly regards such assessments as appraisals of complex economic situations, and it will be quite interesting to see how the upper tribunal approaches challenges to the assessments made under the UK economic interest test and how far it's prepared to intervene in relation to those assessments. Generally, it will also be interesting, of course, to see the impact of Court of Justice decisions on which obviously deal with different legislation on any points of law that are considered by the upper tribunal or the higher courts. Despite the difficulties of challenging sort of complex areas, there are nonetheless many challenges brought each year to Commission decisions in the EU courts. And in fact, I think the Commission's annual report from last year noted that there were, I think it was 24 new cases initiated. So I think one can expect litigation to follow also in the UK. If the upper tribunal decides to set aside the whole or part of the reconsidered decision, it has to refer the matter back to the Trade Remedies Authority or to the Secretary of State, as the case may be, with a direction that the TRA or Secretary of State reconsiders and makes a new decision in accordance with the tribunal's ruling. Appeals from the upper tribunal lie to the Court of Appeal in the usual way, and permission to appeal is needed. It will not be granted, of course, unless either the upper tribunal or where the upper tribunal refuses permission, the Court of Appeal considers that there's an important point of principle or practice to be decided or some other compelling reason to hear the appeal. I think Fergus is now going to make a few comments on the future.
Yeah, get my crystal ball out, which is always a very dangerous activity, and none more so in these very complex times. Well, one thing I think is going to be pretty clear, and as Sarah has just said, there's litigation and then there are hills, and we've already seen the bicycle dispute. And I don't know, because I'm not privy to it, I don't know how the reconsideration has gone, but it has to move quite quickly, because unless a determination is made in the complainant's favour, then the dumping duties will be lifted at 11:01 in 5 weeks' time. So things have got to move on quite quickly, and one would be interesting if the reconsideration went against domestic industry. They would then have to seize the upper tribunal very quickly indeed, possibly ask for interim measures in the form of continuing duties imposed, waiting for an inter partes hearing. Anyway, we'll see. That's for now under the transitional regime. Going forward, I think it's going to be a fortiori, because not only of the newness of the system, I think also the willingness of the TRA to say, look, we're new boys on the block, and we actually quite like this to be determined by a court, difficult points of principle. And thirdly, it's the fact that at the false friends point that I mentioned at the beginning, we're almost the same as the EU, or we're very similar to the EU regime. We're not totally similar to the US regime, but we're not totally dissimilar. unsurprising, really, because they all come from the same Fonds et Origo, which is the GATT and WTO in essence. But we're neither fish nor fowl, and will it be a famous third way? Who knows? Will the TRA want to carve its own path, or will they cleave more to one way or another way? Who knows? Will the courts be willing to take their own position on matters? Again, who knows? But I think what we do know is that because of the lack of certainty and because what's at stake, and you can imagine in these difficult international trade times, that the UK domestic industry and players within it will be seeking as much protection as possible, not least because of Brexit per se and the fact that they've been, to a certain extent, impacted insofar as they trade overseas with the biggest market on their doorstep. So they definitely won't want to have the double whammy of that and being impacted by unlawful trade practices from third countries, which third countries, of course, could include the EU. So I think very little is off the table, plenty to play for, and in that spirit, as Sarah said in her introduction, we intend to be producing and giving further webinars on more specific issues, so walking you through an investigation, walking you through a reconsideration, walking you through maybe an appeal to the upper tribunal. And it would, we always listen to those who wish to listen to us. And if you have any thoughts about what you would like discussed by us or covered by us, please let us know. You can either do it now via the question facility, or just email Sarah or I with your suggestions, because obviously there's no point us having a fun hour giving talks that don't actually impact or interest those who are listening to us. So we're very much, well, I say very much, we are in your hands to an extent, and we will definitely take account of that which you asked for. So thank you very much indeed.
Great. So now there's an opportunity for questions. If anybody wants to address questions, then please do use the facility on the control panel, and we'll attempt to answer those. I've received one observation, in fact, from Aidan Robertson, who said that originally the Competition Act 1998 had a reconsideration procedure for infringement decisions, but that it wasn't really followed up on because resources became very tied up in reaching the same or similar decision. So it will be interesting to see if something similar happens here, or how effective a reconsideration process will be in due course. As I understand it, if somebody wants to challenge a decision, they have to go through a reconsideration first, and then it's only if the request for reconsideration is unsuccessful that you get your chance to go off to the upper tribunal. Very good. Okay, well, Fergus, I don't know if you have a question or two, or wanted to. You're muted again. Muted, I think.
Am I?
Volume. That's better.
Oh, good. I don't think I was actually muted. I think probably something was stuck on my microphone. We've thought about a few issues, a few questions. In practice, how much freedom will the Secretary of State have to come to a view which is contrary to the view taken by the TRA? Well, we've already seen this issue of guidance that's going the other way from the Secretary of State to the TRA, and the TRA must have regard to, but is not bound by, any such guidance. The problem that I foresee is that trade is or can be hyper-political. and the Secretary of State may become involved politically in a manner that doesn't necessarily reflect the nuts and bolts of the trade legislation. But Sarah, do you have any thoughts on that?
I think it will be difficult when there's been a specific investigation, and particularly the points you made earlier about the difficulties of the Secretary of State issuing guidance in relation to particular cases. I'm sure that the design is really that the TRA takes the decisions, but it'll be interesting to see what happens.
Yes, I mean, of course, the Secretary of State could look appalled at a decision of the TRA, and then subsequently, thereby not being out of bounds, if you will, pursuant to paragraph 34 of Schedule 5 of the Trade Bill, actually issue guidance saying thou shalt never do that again. But you're right. I think it's going to be very difficult. But strictly speaking, he or she has quite a discretion, must act in a lawful manner. But my fear is that it may become political. But maybe I'm just being a bit paranoid.
Well, I think in relation to the EU, the position is that there's an opinion-giving committee, and that member states by qualified majority can actually block a Commission regulation in relation to a final measure. So, in a sense, they are obviously largely political decisions, and a number of things have to be taken, as you see from the economic interest test. Effect on employment. I mean, if there's going to be a greater effect as a result of the measure on domestic employment rates, if you grant it, than if you depending on whether the downstream industries, have employ more people than the people being affected by the measure in question. So there are all sorts of issues that might be important to consider.
And indeed, it might become a devolved issue. Because if you imagine steel, for example, which may or may not be produced in Wales very much, but it may impact on a part of the one of the countries in the Union and not impact on others. And what will the Secretary of State do? Will he or she have to take into account that which happens in that devolved area? All these are interesting issues. There was another issue that we thought of, which is how many of the EU's measures are likely to be carried over into the new alleged sunny uplands, and is the EU doing its own re-evaluation in the light of Brexit? Insofar as the former is concerned, as I understand it, having looked at the list that's published on the gov.uk website, most measures are followed. If the EU's decided to lapse a measure, it will be lapsed, and vice versa. But that's not to say that will always be the case. There have been issues with regard to certain steel safeguard measures already, where they didn't go in line with the EU. And I think for everybody who's interested in this area, it's worthwhile keeping an eagle eye on that relevant part of the website, where it just sets out, and I'm sure that list will get longer and longer as we come closer and closer to December the 31st. Insofar as the EU doing its own evaluation in light of Brexit, I'm not 100% sure, Sarah. I haven't heard that it's reviewing any of its trade remedies in the light of Brexit. Have you heard anything on that?
No, but I just wondered whether and obviously we're only one of the group, so in practice the EU measures probably still stand on the same evidential basis, even with the UK being removed from them. But it's always possible, if it's very UK centric, that they might have to conduct a review. Yes. I see that there's a question about whether it's come in about whether we think the UK will introduce a similar regime for foreign subsidies as that suggested in the EU's white paper in the summer. I think this is probably the transnational subsidies point. And I mean, it's interesting. I think that it's been a controversial topic, as I understand it, but I would have thought if the EU is seriously considering it, the UK probably will consider the point too. I mean, in practice, the effect on a domestic industry may be the same as to whether it's your normal subsidy problem or a transnational subsidy one. So I would have thought this would be something that they would look into.
Yes, and it may well, of course, the EU's white paper will, to go back to what we were just discussing a moment ago about re-evaluating its trade measures and its armoury in the light of Brexit. One of its concerns, the whole point about the level playing field, is that it doesn't want the UK to become a Trojan horse or to facilitate Trojan horse activities. And that type of example that you gave earlier with Egypt, China, Egypt, and then could well have some ramifications for the UK. So whether or not we follow them, we may well be subject to it insofar as this new policy, comes into effect in the EU. We'll have to wait and see.
And I think there's one further question that we might be able to deal with before we wrap up. 2 points to make. One is that we've moved on in the slides to the various references for legislative materials, which we hope provide helpful links. And then the other one, I think probably we've been asked to elaborate on the UK's use of remedies gained through WTO settlement by the EU while it was a member of the EU, but now being relied on for UK trade measures as a non-member state, for example, the Boeing case. And Fergus, I don't know if you want to comment on that.
Well, there are arguments both ways. As I understand it, I'm not privy to government thinking, but as I understand it, the UK has made it clear that it will be wishing to impose its own sanctions allowed pursuant to the recent WTO ruling against the US in relation to the aircraft subsidies given to Boeing. First question, can it do that? Because obviously that the complaint and the panel and the decision all happened when the UK was part of the EU and it was an EU complaint. Once it becomes a third country, and it will be a third country member of GATT, and there are of the WTO, and there are issues with that at the moment as well. But once it becomes one, the argument is, well, hang on, you can't then seek to get your benefit from something that arose due to a membership which has now ceased. So that's that argument. The other argument is that, well, we're still affected, we're still here, we're still a member of the WTO. The article, the press article I referred to, which was, I think, a Reuters article dated the 20th of this month, said at the end there will something along the lines of there will be a lot of hard arguments to make about jurisdiction. So I'm afraid I can't answer them now, but there will be a lot of, I would imagine there'll be a huge amount of debate both in WTO, but also possibly outside of that, between, say, the US and the UK. Not going to assist, I would imagine, in terms of a standalone US-UK agreement, but who knows? I'm not a trade negotiator.
Okay. Great. I think we've probably reached the end of our allotted time, so I think we'll wrap it up there unless there's anything else you wanted to add, Fergus.
Nope. Thank you. And we look forward to seeing you again for our series, which will probably take place in the new year.
Thank you.
Thank you.